you, Prof. Gigi. Good afternoon, Dean Leonen, Dean, the present Dean, the 14th Dean of the UP College of Law, Dean Danilo L. Concepcion, the 12th Dean of the UP College of Law, Dean Salvador T. Carlota, Prof. Hardilesa, Prof. Gigi, Prof. Leo, Prof. Florine. Hinuhuli ko, estudyante ko. Okay lang yan. Good afternoon. It is both an honor and a privilege to introduce to you this afternoon the immediate past Dean of the UP College of Law, Dean Marvic Mario Victor F. Leonen, a dedicated academician, a prolific scholar, a trailblazing leader, a man of both intellect and honor. Dean Leonen has been a distinguished member of the bar since 1988. He earned his undergraduate degree in economics at the elite School of Economics, University of the Philippines, graduating magna cum laude in the class of 1983. He proceeded to the College of Law, also in UP, earning his Bachelor of Laws degree in 1987. Fresh from law school, he has been inspiring students, as Dean Danicon said earlier, since 1989, some of whom are now leaders in their own right, not just with his brilliance, but likewise his significant, relevant advocacies concerning national interest issues such as mining and environmental law concerns. He has taught constitutional law, contemporary problems in constitutional law, law and society, public international law, and the 4 remedial law courses, including OLA. He also served as Vice President for Legal during the term of the first woman UP President, Dr. Emerlinda R. Roman. He has been the holder of the Enrique Chan Centennial Professorial Chair of 2008, the holder of the Carlos P. Romulo Centennial Professorial Chair 2009, and also the Metrobank Philippine Judicial Academy Professorial Chair of 2009. Not to sit on his laurels, Dean Leonen went on to work for his Master of Laws degree in Columbia University, New York in 2004, soon after his fruitful stint as Director of the UP College of Law, Office of Legal Aid. His works, which focus among others on indigenous peoples, the environment, and the Constitution, are used as references both by those in the academe and in the private practice of law. Some of his works include 1. A Divided Court, A Conquered Peoples, Notes on the Supreme Court Decision on the Constitutionality of the Indigenous Peoples' Rights Act of 1997. 2. Philippines, the Dispossessed Victims of Development. And 3. Mining, Legal Notes and Materials. The nation's man of the hour, he is currently serving the people through his post as the chair of the Government of the Philippines Peace Negotiating Panel for talks with the Moro Islamic Liberation Front under the Office of the Presidential Advisor on the Peace Process. I'm sure you all know time is never enough to include all the achievements and works of this busy man, and I know you're all excited to start this afternoon's lecture. And so without further ado, please welcome with me now Dean Marvic Mario Victor F. Leonen.
Thank you, Professor Dawai, for a very generous introduction. I hope that the lecture would be better than the introduction. Dean Danilo Concepcion, former Dean Salvador Carlota, future Dean Patricia Dawai, future Dean Florine Hilbay, future Dean Chithar de Lesa, Professors Bautista, Professor Batad, and I think I saw Professor J. Batumbakal a while ago, Justice Castañeda, friends, students who have come here voluntarily, especially my class in constitutional law and my mythical class in constitutional law in De La Salle University. They were also forced to come here by the professor that substituted for me. Good afternoon. The topic for today carries a very weighty title, and we entitled it "The Constitution at its Margins: Postcolonial Issues and the Flexibilities of Legal Metanarratives." Do not worry, I will justify the heavy title later on, and I think the heavy title is also justified by the requirement that these lectures, called the Law Centennial Lectures, are supposed to be lectures that should provoke rather than simply inform. I thought that it was my duty not to create a long Langdellian string of doctrines, but rather to entice you to think more closely about some things about our Constitution, especially in relation to some particular issues. Next slide. Next slide. In order to clarify my standpoint as of the present moment, I speak here as an academician. I do not speak here as the chair of the government panel in talks with the MILF. And thankfully, no media person is here. If there is any media person, please exclude yourself from the audience, because I might be revealing certain thoughts that are in the groups of those that are discussing the solution to what is called the Moro question down south. But in any case, I speak as an academician, and therefore all the thoughts that I share with you are simply mine. It is not reflective of my principal in the talks, who is none other than the President of the Republic. And I thought it was best for a lot of the public to get into the group of thinking about some of the problems that we now have. Next slide. The title was brought about by what I would call an academic angst that have bothered me ever since I have taught constitutional law. You see, I started off as a public interest lawyer working with indigenous peoples, the disappeared, human rights, FLAG, and many others. Of course, in terms of the academe, there are what is called the meta-narratives, things that we take for granted, stories about stories. And three of them have bothered me for the longest time. The first is the concept of the social contract, or the idea in its current reincarnation that states that the people as sovereign wrote our constitution. Of course, in the olden times, this was called a social contract of people getting together and agreeing in Lockean terms to surrender part of their liberties in order to create a civil government. In Hobbesian terms, on the other hand, it means that there are certain rights that they took into consideration, placed as part of their autonomy, which is now in the Bill of Rights, and therefore all the extra rights would constitute civil government. Depends on how you would look at it. And of course, the social contract is, or that the people wrote the Constitution, is something that is bothersome because there has never been an actual meeting of these people. Neither is there an actual meeting of all the thoughts of peoples within the Republic of the Philippines, especially starting from the Las Islas Filipinas, down to its reincarnation as a Commonwealth, then to a Republic, then under martial law, and then now as a Republic of the Philippines. The second meta-narrative that bothers me is the concept of people, more particularly people and people as persons. People, from the point of view of liberal positivism, are supposed to be atomistic, rugged individuals that do not communicate with each other. And hence, more often than not, when we read the cases in the Bill of Rights, it seems to assume that people who are affected, or the persons that are affected by the Bill of Rights, operate as individuals that create identities by themselves, not in relation to other kinds of peoples, of other cultures, or other persuasions. The last kind of meta-narrative that bothers me, and I think bothers a lot of the professors that teach constitutional law, is the concept that whenever you change the Constitution, immediately there will be changes in reality. Or, for that matter, that whenever you change the law, that there will in fact be a change in reality. That there seems to be a disjoint between what we believe should be the normative structure of our legal order, but on the other hand, what really happens out there. Next slide. You see, meta-narratives are stories about stories. They are stories that are packaged as universal, perhaps even inevitable. They have, for various reasons, the tendency to dominate a framework that produces knowledge and explains our experience. Legal meta-narratives become powerful frames, especially because they are repeated in ordinary literature, in popular media, and even in everyday explanations of why the law is legitimate. Notice, for instance, that whenever the Constitution is at stake, some commentators would say that the Constitution is the product of the people's hands, whereas in truth and in fact, you all know in Article 17 that it goes through certain stages, that the real work happens in a deliberative forum, either by a constituent assembly within Congress or a constituent assembly in a constitutional convention, or in that rare case, through a proposition by the system of initiative. Meta-narratives may take the form of myth, like social contracts, but in their simplicity may gain traction. Another example of a meta-narrative, the concept of nation, or the concept of nationality. Next slide. The angst is fed by current work of some lawyers with indigenous peoples in this republic, knowing that there are many other ways of understanding knowledge, of actually reframing their experiences. Indigenous peoples normally challenge our framework with respect to the stories behind our Constitution. Also, currently, this angst has been brought forward some more by the fact that when you negotiate with entities or movements or insurgent groups, like the Moro Islamic Liberation Front, sooner or later you will find out that their meta-narratives, their stories about their own stories, is really radically different from the stories that we have in relation to our Constitution as found in our jurisprudence. This, I think, provide the realpolitik that drives an academic angst that may be shared by a lot of constitutional law professors. Next slide. These meta-narratives, that of indigenous peoples, as well as the Moro question, as we would refer to them, are post-colonial questions, in the sense that the problems presented by the concept of indigenous peoples are post-colonial issues, in the sense that we accept that the goal of post-colonial theorizing would be to clear the ground to allow a democratic space that allow for multi-local, polyvocal, and multidimensional discourses. This becomes urgent in situations where laws that apparently recognize liberty, equality, and democracy, in fact, foster dominant ideology and privilege some cultures over the other. And that is why part of the title refers to post-colonial issues. That we have adopted a kind of structure where we seem to accept that all peoples are of a universal character, that there is such a thing as universal citizenship, and that this citizenship transcends our cultural and ethnic identities, or even our religious identities, and that therefore we should be considered as citizens first, and that is what is more salient than any of our identities. It's a post-colonial question because it comes after our liberation, theoretically, and then we start to discover that in truth and in fact, our cultures may be different, and the ways we think about certain things may be different. Lastly, the angst is fed by a quotation, again, from Robert Cover, one of my favorite authors. Next slide. That legal interpretation, in fact, does violence. And let me read from this quote. Legal interpretation takes place in a field of pain and death. Well, of course, if you are law students, you know this literally. But let us assume that you are now practicing lawyers so that you understand it more fully. This is true in several senses. Legal interpretative acts signal and occasion the imposition of violence upon the others. A judge articulates her understanding of a text, and as a result, somebody loses his freedom, his property, his children, even his life. Interpretations in law also constitute justifications for violence which have already occurred or which is about to occur. When interpreters have finished their work, they frequently leave behind victims whose lives have been torn apart by these organized social practices of violence. Neither legal interpretation nor the violence it occasions may be properly understood apart from one another. This much is obvious. Through the growing literature that argues for the centrality of interpretative practices in law, blithely ignores it. Your power as a lawyer are embodied in the words that you will utter. that you will write in pleadings. With that simple pleading, you will move the entire state bureaucracy against or in favor of a client or another person. It is not your muscle, but your words that are going to change situations for many of your clients. And I hope we start to realize that our interpretative acts does have real consequences upon our societies and upon the peoples that embody these societies. Next slide. To remind us of that reality, this is a picture of two children in a Bilaan community up there in Salnaong, which is now the base camp of formerly Western Mining Corporation. And apparently, this hut and these people are no longer there. Mining is actually occurring there. And we lost the case in Labugal versus DNR. And because we lost the case and some others' lawyers' words became more powerful because it was accepted by the Supreme Court after reconsidering its decision, it indeed created violence on these families. I do not know where this family is already located. Next slide. The claim that I make is that the text of our present Constitution, regardless of where it came from, can accommodate the aspirations of indigenous peoples and can lay the basis for fundamental solutions to the moral question, provided that we are conscious of the reasons why we read the Constitution in a particular way, and even more aware about whether we succumb simply to the inertia of given meta-narratives, notably that of the liberal democratic inspiration of the Constitution from which we copied from. Of course, I have a sub-claim, and this one perhaps may be implied from the lecture today, and this is that there can be no permanent reading of the Constitution. And I know that this is going to be quite controversial for people that are schooled in a Langdellian sense. Well, of course, in the UP College of Law, we all understand that there can be no permanent reading of the Constitution given the reality that there are 15 justices that will change over and over again. Now, next slide. I wish to approach this subject or approach the proof of my claim first by going through a proposal on how to read the Constitution. So we now go into reading the Constitution. Next slide. First, we have to understand that there is a distinction between normative expressions, these are provisions found in law, and that which are known as descriptive statements. Of course, you know the distinction now in terms of your digest of cases. There is a difference between law, statements of ought, what should, ought or what must be, and on the other hand, statements of facts. And we know that statements of facts now can be verifiable in the sense that you can actually use your sensory experiences to know whether or not they exist. On the other hand, normative expressions are not viable to that way of verification. Normative expressions, on the other hand, are statements of ought, and therefore they are statements of future conditions. Hopefully, that will happen, but then therefore you cannot check it in relation to the existence of actual facts. Normative expressions, therefore, necessitate that there should be other normative expressions of a higher order in order to be able to validate its existence within a legal order. I say this because I think that our Constitution is necessary. Necessary in the sense that without it, there will be no legal order. There is no legal order simply because there is no way to check the validity of all other subordinate norms. And therefore, when you really look at the Constitution, it is fundamental simply because it is necessary. It is not fundamental because it comes from a social contract created by all citizens. It may not be also fundamental simply because it is only the work of the sovereign, but it is fundamental simply because there is a necessity of a constitution. Read in this particular manner, therefore, we look at the Constitution more from its utilitarian value, shorn of many of the stories behind it, and therefore we'll read it in a more realistic way. Next slide. Next premises in terms of interpreting law and the Constitution. Next. Law is represented by words. I think this is obvious. But I think the key concept here is the word representation by words. In other words, there may be certain ideas that go into the formulation of that text, certain ideas of people that actually wrote it for the first time. But then on the other hand, words are part of some dialogue or some communication, and that at certain times the words change their meaning or change their representation simply because the context of that conversation will also change. Law is represented by words, but it is not necessary that those words that were originally written is intended to work in the same way in which it was originally written. Next slide. The words create norms. And by norms, we say, again, suggestions of behavior in the future. The words are created by human beings, and therefore there is nothing sacred about it, except that, of course, it may be more necessary than other statutes. And on the other hand, therefore, it simply states that there must be a kind of conduct that it requires. Next slide. Any standard of behavior, called a norm, are conjunctures of present understanding when it was written. In other words, they give privilege to how things should be the way people who wrote it understood it to be. Simplest example, driving at the right side of the road is a convenience, but it is a norm. It could have been that we should drive at the left side of the road. Another simple example, presidential form of government was created at the moment that the balance of elite forces in, let us say, the Constitutional Commission, I think it won by one vote, that they understood that it was quite necessary to have a presidential form of government. And therefore, at that moment, the norms creating this structure of government was the understanding. And therefore, at that moment, and up till now, it reflects that kind of understanding. Next slide. The understandings that impel the norms, the values that dominate while the norms are created, struggle for dominance in forums where canonicity exists. In other words, at the time when the Constitutional Commission was deliberating a draft of the Constitution, the debates in the media were important, but not as important as the debates that were going on inside that forum. When a case is being decided, let us say in the Court of Tax Appeals, or perhaps in the Supreme Court, what matters really is the deliberation in that forum. The other deliberations may have some indirect effect on the people that decide it, but on the other hand, we must be very clear that the understandings that really struggle for dominance are those within that particular forum. And finally, we should relate, again, the canons that we have in terms of interpretation and in terms of doctrine and our discipline. That in a certain way, our discipline is more protective of the fact that we should have a discipline sometimes, rather than whether those canons really have relevance out there. Again, the Langdellian way of studying law requires that we look at the doctrines and memorize it and accept it and not change it, perhaps. That would be the implication. But on the other hand, there are certain doctrines that we have which may have nothing to do already with reality out there. And of course, now we say that perhaps it is time that we look forward to something more relevant in terms of the ways that we interpret the text of the provision. Next slide. Question that we always ask is, why not simply make a political statement when you write a decision as a member of the court? After all, if there are many ways of interpreting those provisions, then why not simply structure it and defend it as a political statement of the court? And of course, we have, again, another meta-narrative existing within our profession, and that is that our courts, our judiciary, performs at a certain level of neutrality and objectivity, different from the crass kind of political maneuvers seen within the executive or that of the legislature. There must be some reasons that are given to it, and those reasons, therefore, would mean the neutrality and the objectivity for that kind of an interpretation. Next slide. Again, let me emphasize. Law is not dependent for its existence on whether it is moral or even whether it is just. Again, I know that this may be a controversial statement, Again, I am using it as a heuristic. There are some laws that are moral and some laws that are just, but they do not exist because they are moral or just. An unjust law can still be law. An immoral law can still be law. Notice, for instance, the punishment given to prostitutes who can only be women. I don't think that that is just. I think that person to be punished are the men or the others that take convenience out of those services. But then your law provides such. Law is a human creation. It comes into existence and given its meaning by the various motives of individuals and collectives of individuals. Individuals, on the other hand, make decisions socially and culturally. Their choices are limited by political reality. In a sense, therefore, law is a compromise of those that have a say within dominant institutions, believed to be relevant. It is therefore not the product of common sense or pure logic, or perhaps even of pure necessity. Hopefully, these words will inspire you to actually go beyond, again, the doctrines provided by that law. Next slide. There is a need, therefore, for us to have some consciousness that the Constitution is a necessity for the current legal order to exist, for there to be a rule of law. However, that the legality found in it is different from its legitimacy, and our hope is that legitimacy is more than simply compliance with the constitutional provision. It has something to do with salience, or also its relevance. And what we should move forward to is an interpretation of the Constitution, not simply on the basis of what its words are, but on the basis of whether the Constitution can become more important, more necessary, and more relevant to our present conditions. Next slide. Of course, this takes place within the frame of our discipline, and that therefore we should try to be creative within the methodologies given to us. Next slide. The flexibilities given to us in relation to the provisions of our Constitution are at 5 levels. The first is to understand the context under which the provisions are made, are invoked. By this I mean that certain facts can be made relevant only by the parties or because the parties are interested in it. And on the other hand, it is always a game of two sides. The other side, usually the Solicitor General in cases of the Constitution or constitutional issues, also make relevant and privilege other facts. Sometimes there are facts which are important, which are not privileged by both sides. And therefore the context where the Constitution is deployed will therefore be limited. Notice, for instance, many of your cases that have been decided on the basis simply of justiciability, rather than talk about, let us say, the Foreign Incentives Act in Garcia versus Executive Secretary. The Supreme Court dealt with the question as to whether there was a case, remember, or whether the party had legal standing to actually sue. The second is the inherent ambiguity found within provisions or text. The third is the different interpretative modes that we can deploy, and more of this we shall see later. The fourth would be the standpoint by which we are reading the Constitution, and finally, the procedures that we deploy. Next slide. Ambiguity is found in text. Which of the texts of the Constitution will be relevant? Is this a situation where we apply Section 2, Article 12 of the Constitution, which of course you all know, or theoretically know, as the provision that governs the concept of land as public domain? Or is this a provision where Article 12, Section 5 applies, particularly the second paragraph, which of course I am sure all of you know as the provisions governing ancestral domain? Because if it were ancestral domain, as the text being deployed in a particular case, the kinds of jurisprudence that comes with it are sparse, but on the other hand, gives a lot of chance to people that can actually own ancestral domain. The ambiguity is created by which text is chosen by the parties and the courts to deploy. And then, of course, there is the natural open texturedness of words found in legal text. Open texturedness. No person shall be deprived of life, liberty, or property. Then on the other hand, you are taught that private property shall not be taken for public use. But then on the other hand, you start to understand that there must be a difference between deprivation and taking. And with respect to taking, you have a case, Republic versus De Castelvi, that have 5 elements to determine whether taking has happened. But on the other hand, with respect to deprivation, you have nothing to use except those cases which define police power in such ambiguous terms that you do not know when there is a deprivation and when there is not. Again, those words are open textured. It can have a lot of meaning. Third is the context or the structure, the sentence of the paragraph in which it is found. And you saw an example of this in the case of the Midnight Chief Justice, where something that was to us prior to that case never deployed, which is where you actually find the provision, that it is found in Article 7, the executive, that would matter after all. Therefore, that kind of structure was used in order to be able to create a new ambiguity in the provision, in spite of the fact that the text found in Article 7, Section 15 was very clear in relation to the power of the President to appoint within the last 2 months of her presidency. Then finally, the context of cases. You have heard from your constitutional law professors. Difficult cases always makes bad law. Difficult cases, these are the politically charged cases. These are the cases that look into culture. These are the cases that will pander to biases of the public, are normally those cases where the Supreme Court waffles because they look at what the political interests are as of the present, and therefore the intervention of culture, history, and politics in particular cases. Next slide. Of course, we know that our Constitution has been revised several times. 1935, 1973, 1986, among others. 1973, amended in 1976, then 1984. Okay, we remember because we were students of the law when the Constitution was amended twice. And when we finally was about to take the bar, we realized because of people power, there was a new constitution that we will be using in political law. And we were that batch that actually took that, and perhaps that is why a lot of us are so very interested keenly in the Constitution, because we can move to the 73, the 76, 84, or 86 Constitution. Constitutional revisions create ruptures in terms of the words that are used. But on the other hand, normally, in terms of constitutional changes in this republic, many of the usual provisions are kept, and they are not changed. They are not changed because there seems to be that unshaken belief that some of those provisions carry jurisprudence with them that cannot be changed. But when you look at some of those provisions very carefully, then you would start to realize that perhaps we have again reinforced a kind of narrative which is not now relevant. Witness, for instance, the concept of public domain. Witness, for instance, the concept of Regalian doctrine, and so on and so forth. But in any case, again, in relation to looking at the Constitution, we should be very aware that there are certain ruptures in terms of the amendments of the Constitution. Next slide. You are told that there are certain ways to interpret the Constitution. And let me reveal a secret. No constitutional law professor will tell you what is the correct method. I will repeat. In terms of teaching the Constitution, all of us are in on a dirty secret. And that is that there are choices of interpretative modes. There is a limit to that universe, but there is none which is always salient all throughout. Again, looking at the usual terminology, verba legis, strict construction, and this has something to do with casus omissos pro omisso habendus est. You know this. Or expresso unius est excluso alterius. You also know this. Expressum facit cessare tacitum. You also know this. Of course, we are sounding lawyerly, but when you actually look at it, these are rules of grammar and nothing else. But we use Latin to increase our attorney's fees. Okay, in any case. So verba legis looks at the terminology. Congressman Rufus Rodriguez is here. His attorney's fees are more than any of us. Just kidding. In any case, so therefore, the first modality is to simply look at the text. And looking at the text, again, the pretension that the text itself tells its meaning. Whereas in truth and in fact, now every theory of language would say that the text by itself does not carry meaning. It's the text in the context of a conversation or in the context of a communication, even a legal order, that creates its particular meaning. Of course, contrary to verba legis is another modality that we usually use. Rationem legis est anima. Again, the reason for the law is what animates it. Normally, this is what you say when you pass through a red light accidentally. Rationem legis est anima. Because then if the text is very clear, then sometimes because of the context of the application of that text, it may be that the interpretation may be different just to give the intent or the motive behind that provision some salience. And of course, utres magis valiam quam perea, which means that you would look at all the four corners of the document in order to interpret it. You encounter cases where some privilege one interpretative modality over the other. You encounter cases where they try all three. And in trying all three, they discover that two come out with the same result, and therefore they would choose the other one rather than what is suggested. You would encounter cases that do not even discuss why the other methods are not applied, but simply again because there is such flexibility in terms of interpreting the Constitution. In all cases, the text is the common anchor. In all cases, the words of the Constitution matter. And there are some constitutional provisions that are easy, such as the age requirement for becoming President of the Republic of the Philippines. Very easy. Such as, for instance, some of the conditions under which a president ceases to be president and the vice president ceases to be acting president and becomes the president. Death, for instance, is very clear. But then on the other hand, we thought that resignation was also clear in Estrada versus Desierto. Yet the Supreme Court said resignation can happen even without the resignee resigning. It depends on the context, again, of that particular provision. Or for that matter, we thought that there is a necessity for actual elections or actual plebiscites where you have secret ballots in order to be able to ratify a constitution. But then you have been punished with Avellana versus Executive Secretary, where we all discovered that because of the difficult political circumstances at that time, the Supreme Court at that time, and only at that time, ruled on the case without any legal basis and simply said there are no further judicial obstacles for the Constitution coming into play. Next slide. I will dare say that there are fallacies of interpretation. And the fallacy is that there is such a thing as strict construction and it will tell you its meaning. The other fallacy is that the original intention will tell you the meaning of the Constitution. It is important that we understand that looking at the text is important, and perhaps having guidance from the original intention is also important, but they do not by themselves actually tell you the interpretation. Next slide. So text is important. Next slide. Law plus history is not enough. Number one, because of the ambiguity of historical narratives. Let me tell you about Civil Liberties Union versus Executive Secretary. Under the ponencia of Justice Vivi Mendoza, he said, those that wrote the Constitution do not sit in our chambers. It is us that sit in our chambers. They may guide us, but they are not the justices of the Supreme Court. This was his way of saying, do not cite to us the deliberations of the Constitutional Commission and tell us that that matters absolutely for us. But rather, it is us that will decide and we will get guidance from them. And therefore, there is ambiguity in historical narratives. For instance, no person shall be deprived of life, liberty, or property. Carino versus Insular Government gave a certain meaning to it. But on the other hand, if you look at its original history, from the annals of the Constitutional Commission or Constitutional Convention records of the Philippine Constitution, you will find nothing. But if you go back to the American Constitution and look at the Federalists, then perhaps, or even the discussions that have been made in relation to the amendments that were incorporated in the American Constitution, then perhaps you would have an inkling of the original intent. An author in fact, in the United States asserted that if you looked at original intent, the original intention of those that gathered, I think, in Philadelphia to write the Constitution was that they did not want the records to come out. They wanted it to be kept in secret because they wanted the text to speak for itself. Therefore, the original intent was no original intent. The ambiguity of historical narratives. But I think for the Philippines, or countries like us, there is one more important reason why history is not sufficient for our text, and that is the concept of the postcolonial. And let me quote an author to explain this. This is Iris Marion Young, and she called this cultural imperialism. Note, these are her words, not mine. And she deployed the word imperialism, I think, so that there will be more emotive force to the character of the concept that she was deploying. To experience cultural imperialism means to experience how the dominant meanings of a society render the particular perspective of one's own group invisible at the same time, as they stereotype one's group and make it out as the other. Remember your rules on evidence. Remember the best evidence rule. Remember the parole evidence rule. Of course, some of you still do not know it. You're in first year. But the parole evidence rule in evidence says that when all agreement is reduced to writing, there can be no other evidence except the writing itself. That privileges a culture that gives primacy to a written document. That does not privilege a culture that gives primacy to words of honor. It gives primacy only to the written document, not words of honor. As a matter of fact, it excludes any other discussions prior to it. Prior to that document in terms of evidence. Of course, a very perceptive student that I had in the past actually told me, "Sir, I think there is more to that." That kind of rule privileges lawyers. Because as a matter of fact, it's lawyers that write agreements. And therefore, it does not privilege the parties that actually enter into the agreement having a sense of what really their agreement is all about. I said maybe yes for some lawyers that are not diligent enough to check with their clients as to whether that is the intention. The point is that there can be certain things which are seemingly neutral, which actually excludes certain kinds of cultures or ways of understanding or ways of knowing. Next slide. Again from Marion Young. Cultural imperialism involves the universalization of a dominant group's experience and culture and its establishment as the norm. Some groups have exclusive or primary access to what Nancy Fraser calls the means of interpretation and communication in a society. As a consequence, the dominant cultural products of the society, that is, those most widely disseminated, express the experience, values, goals, and achievements of these groups. Next slide. Often without noticing they do so, the dominant groups project their own experience as representative of humanity as such. Cultural products also express the dominant group's perspective on and interpretation of events and elements in a society, including other groups in the society, insofar as they attain cultural status at all. And the culturally dominated undergo a paradoxical oppression in that they are both marked out by stereotypes and at the same time rendered invisible. As remarkable deviant beings, the culturally imperialized are stamped with essence. The stereotype confined them to a nature which is often attached in some way to their bodies and which thus cannot be denied. These stereotypes so permeate that society that they are not noticed as contestable. Just as everyone knows that the earth goes around the sun, so everyone knows that gay people are promiscuous, that Indians are alcoholics, and that women are good with children. White males, on the other hand, insofar as the group markings, can be individuals. This is Iris Marion Young. Two other authors had the same conclusion. Next slide. And this is in the form of the concept of a subaltern in postcolonial theory. Of course, you know Antonio Gramsci that again deployed the use of the concept of hegemony and said that there are certain individuals he called the subalterns. Unfortunately, a militaristic term, who may not be able to participate in the creation of ideas that dominate a particular culture. Of course, one of the later authors, Gayatri Spivak, also is famous for that article which asked the question, can the subaltern really speak? We will discuss that a little bit later. Now, you may say this is all theory, but again, a favorite case. Next slide. People versus Kiya, a landmark case for the interpretation of that clause in the Constitution found in Section 1, Article 3, which is, nor shall any person be denied equal protection of the law. The story is very simple. Kiya has one name. He was Ibaloy. At a certain time of the night, he was caught drinking A111 gin. I don't know whether you know A111 gin, but if you do, you betray your generation. But in any case, A111 gin, and there was a law, Act number 1639, and you can actually see it still in the library. Of course, it was already repealed, which actually made it a crime for natives to drink non-native wine after curfew. Natives to drink non-native wine after curfew. The inspiration for this was the concept of parens patriae, that because these natives were non-Christian tribes, that they needed the protection of the state against themselves. Of course, we all know the effect of any kind of gin on our bodies, regardless of your ethnicity. You can do that experiment later just to really find out. So the Ilocanos, Tagalogs, etc., you have a control group that will not drink anything, a very sad group. But in any case, the point is that Kiya was languishing in jail. And a UP Law alumni by the name of Sinay Hamada found him languishing in jail. And Sinay Hamada, of course, at that time, the only way by which you can become famous as a lawyer at that time was to look for a client that had a very good case. And he found Kiya. So one of his first cases was actually to file in the Supreme Court of the Republic of the Philippines. Hamada is class of 1937. He filed in the Supreme Court of the Philippines a petition for habeas corpus as a post-conviction remedy, alleging that the law upon which Kiya was incarcerated was null and void ab initio because it violated the Bill of Rights. He seemed to have a very good case, and there seemed to be discrimination written all over it. You cite People versus Kiya for the four-way test for equal protection. It is this case that introduced the four-way test copied from jurisprudence from the United States. But in effect, it says that it said that the conviction of Kiya was understandable and therefore had good reasons. And it was germane for the purpose of the law because there were certain things about non-Christian tribes which allowed the state to protect them. Because prior to this case is another very important case, next slide, entitled Ruby versus Provincial Board. Again, one of our favorites. I learned this all from Professor Dr. Owen Lynch, who is there. And I hope I'm reciting it properly so that I get a better grade than what I got from him. In any case, Ruby versus Provincial Board, the ponensya is none other than George Malcolm. Yes, the same person for whom this college or this building is named, Malcolm Hall. He wrote this decision. And the problem in this case was that among yan, Ruby petitioned the Supreme Court on a petition for habeas corpus alleging that its rights to liberty had been betrayed because they were being corralled into a poblacion. And he said his right to liberty has been transgressed for no reason at all. And of course, there was a law that said that non-Christian tribes may be relocated into particular places in order to be able to civilize them. Of course, Mangyans were already Christianized. And therefore, you had the problem, the classic problem. Non-Christian tribes as a legal term. Does it apply to tribes that had already been Christianized? And of course, the infamous case said that, of course, non-Christian tribe is a legal term. And it does not mean that the person is already Christianized or non-Christian. It has nothing to do with religion. But it said it has something to do with the nature of the citizen. Again, essentializing the citizen. The Mangyanes are citizens of a low degree of intelligence and Filipinos who are a drag upon the progress of the state. That was what they said about non-Christian tribes. Again, cultural imperialism. That there are certain kinds of stereotypes that we attach to certain kinds of individuals. When we say indigenous peoples, immediately I think that many of you have a vision of what those indigenous peoples are. More so, when we say Muslim or Moro, that you may have already a vision of the stereotype of these peoples that we have in this republic. And therefore, it is important for us to understand that at certain moments, even in our jurisprudential history, we had these types of jurisprudence. And therefore, it is difficult because of this post-colonial reality to simply refer to our history. Next slide. Summary. To read the Constitution, we use the text as the anchor. History and jurisprudence are indicative. We discern values and social balance from other sources. And law should always not be an autonomous discipline. And interdisciplinarity, if we want to deploy it, should also be disciplined. Next slide. Reading the Constitution is a present act, framed by text and guided in part by its traditions and its past, authoritative reading. Being a present act, it attends to contemporary situations with norms that embed an understanding of relevant values. Constitutional construction should neither be a slave of the dictionary or the imagined ideas of those who were privileged enough to write it in the past. The next part, so the first is looking at how we should interpret the Constitution. The text is important. It is the anchor. There are certain disciplines in terms of interpreting the Constitution. These are flexible. And it is not the dictionary nor the intentions of those that wrote it that will perhaps give us the correct solution. It may be a mixture of all, but what is more important is to look at the values that are embedded in our basic documents. Next slide. We have identities. And it is important for us to understand that when we say people or persons, we do not refer to only a single kind of people or a single kind of person. Next slide. Culture embeds law, and law embeds culture. Culture is a set of shared signifying practices that are always in the making and always up for grabs. Contrary to popular opinion, culture is not something that you find in a museum. Culture is some way by which all of us have common practices and understand the things that we do. Law partly generates the signs and symbols and signifying forms with which difference is constituted among meanings. Clifford Geertz said that law is one distinctive manner of imagining the real, that law participates in the creation of our culture. Law, therefore, has a constitutive function. Next slide. I took the author Kiya as an example. Kiya is believes in political liberalism. He believes that there is such a thing as a republic. But on the other hand, he has ceased to believe that the subject of the republic is a liberal atomistic individual. He, in fact, questions whether, in fact, it is right to assume, like Locke, that when we leave people to their own devices, life will become brutish and short. And therefore, he says that perhaps we should see individuals as having multilateral citizenship, that it is not only loyalty to the state that they have, but also loyalty to their identities. And therefore, to him, there is a necessity to actually recognize special group rights because this is essential to participative democracy. This is a quote, next slide, from Kiya. I will not read it in the interest of time. Next slide. Apart from him, of course, some feminist authors. Again, Iris Marion Young and Nancy Fraser. Both of them believe that group rights are important also as a good in itself, not only as a function of participative democracy, but in order to acknowledge the importance of individual autonomy. After all, you become individuals because you define yourself vis-a-vis others. In other words, you have a family name, and that family name distinguishes you, but it only becomes relevant whenever others also have their own family names. You are law student. That only becomes relevant when there are others who are not law students. You are male. It's only relevant if there are females, in many senses, and vice versa, or never vice versa, if you know what I mean. become an expert in the law only in relation to non-experts in the law. You create an identity because you are related to others. And I think their point is that in a certain way, our individualism is not a priori, but it is something that you establish vis-a-vis others, and that is a problematic which our Constitution really has to deal with. Iris Marion Young therefore said that this concept of universal citizenship, where all of us are given the same rights, may not be relevant anymore. Next slide. And therefore she says, impartial general perspective is a myth. People necessarily and properly consider public issues in terms influenced by their situated experience and perception of social relations. Different social groups have different needs, cultures, histories, experiences, and perceptions of social relations, which influence their interpretation of the meaning and consequence of policy proposals and influence the form of their political reasoning. Next slide. These differences in political interpretation are not merely or even primarily a result of differing or conflicting interests. For groups have differing interpretations even when they seek to promote justice, and not merely their own self-regarding ends. In a society where some groups are privileged while others are oppressed, insisting that as citizens, persons should leave behind their particular affiliations and experiences to adopt a general point of view serves only to reinforce that privilege. For the perspectives and interests of the privileged will tend to dominate the unified public, marginalizing or silencing those of other groups. There is now a law which recognizes that we should have daycare in many of our workplaces. Imagine that time when it was considered that everybody should be able to work 8 hours a day without caring for their children. And that in effect marginalized women and men that wanted to take care of their infants or young children. But because the law changed, therefore, it started to recognize this special group interest called daycare. There is a law now, I think it came out in the bar, thanks to Professor Batad and company, the Solo Parents Act, where it was usually considered that all couples and all families should be heterogeneous, which means when there was heteronormativity, that there can only be a family if there is a mother and a father together. But of course, we all know that it is possible to have different combinations. And even the fact that we call them non-traditional families is in fact, from this point of view of Marion Young, a bit oppressive. Again, this brings us to a problem. And this problem is, if law tends to generalize in order that it can save in administrative costs, that we tend to generalize the provisions, then therefore at what level of nuance should we allow our laws to have in order to be able to attend to many of these relevant identities? I want to share with you finally one more author on identity, and this is Gayatri Spivak again, an Indian feminist. In her work, she asked the problem, can the subaltern truly speak? And her answer was, no, the subaltern cannot speak. Because if the subaltern now becomes politically relevant, she or he is no longer a subaltern. Marion Young, Gayatri Spivak, comes out with a common solution. And this common solution can be best described in some things that we know today. Example, autonomy. Example, local constituent political units. Example, associations. Example, unions. And therefore, I think it is an important part of our liberal democracy from their point of view to understand that it is important to have or understand that these structures are important. Yet, a qualifier. Next slide. But it is not proper to essentialize. In other words, we are composed of so many identities. Diane Fass defines essentialism. Next slide. The essentialism is most commonly understood as a belief in the real, true essence of things, the invariable and fixed properties which define the whatness of a given entity. Importantly, essentialism is typically defined in opposition to difference. The opposition is a helpful one in that it reminds us that a complete system of cultural, social, psychical, and historical differences, and not a set of pre-existent human essences, position and constitute the subject. However, the binary articulation of essentialism and difference can also be restrictive, even obfuscating, in that it allows us to ignore or deny the differences within essentialism. Next slide. Kaya Spivak again cautions that even the subaltern is heterogeneous. Let me go into a very controversial topic. Even among the Ibaloys, and this is the culture that I have grown with, even among the Ibaloys, there are Ibaloys that are Ibaloys, and there are Ibaloys that consider themselves more molecular biologists than Ibaloys. There are certain Ibaloys that consider themselves more as lawyers than as Ibaloy. And as a matter of fact, there are differences also among the understandings of their different cultures as of now. In every society, I would hazard to guess, there are always subversive elements. By subversive, I do not mean it in a communistic sense. By subversive, I mean elements that have adopted cosmopolitarian views or views from another culture that are embedded into that culture and again make that certain culture dynamic. Therefore, when you say moral, what do you really mean? When you say Muslim, what do you really mean? When you say Christian, what do you really mean? And not all Christians are Christians. I think you know what I mean. But the point there, not all law students are law students. Okay, just to complete the picture. And the point there, therefore, is that we have to be careful to use a particular essential feature of an identity for purposes of recognizing rights into law. It has to be appropriate. Beatrice Spivak calls this strategic essentialism. At a certain point, necessary in order to address the post-colonial difficulties, it may be important to recognize minority rights, but at a certain stage, perhaps this will become a burden more than it assists. Classic example within the UP system, as we all know, there is a quota system in medicine. 50% male, 50% female. Now, the females are complaining because the slots that are supposed to be given to them are now given to males. Because in terms of their entrance exam, females rank higher than females. And because there is a quota now, it is working against them. Because the quota is essentialized in biological identity, females and males. Of course, fortunately, we do not have that in law school. What matters is merit, but then again, when you privilege merit, are you therefore privileging certain kinds of schools that have the better kinds of professors? And are these the schools that are closer to Metro Manila or within the vicinity? Just a question. But the point there again is that it is important for us to understand that all our law that recognizes identity must recognize it at a particular time, a contemporary period, that these identities may not become permanent. Next slide. So now we go to some constitutional provisions. Next slide. 1987 Constitution. There is the concept of people. Let me locate some of it. In the preamble, next slide, in the preamble of our Constitution, it actually says that the sovereign Filipino people, imploring the aid of Almighty God in order to build a just and humane society, establish a government that shall embody our ideals and aspirations, promote the common good, conserve and develop our patrimony, and secure to ourselves and our posterity the blessings and independence and democracy under rule of law and a regime of truth, justice, freedom, love, equality, and peace do ordain and promulgate this Constitution. Again, the question, what does sovereign people actually mean? Does it refer to only one people? In fact, to be controversial, does it refer to only one source of sovereignty? And for that matter, therefore, for some of our communities that were sovereign pre-colonial, sovereign before the coming of our colonial masters, does sovereign Filipino people therefore include those concepts of sovereignty? Or are we simply attached to the kind of sovereignty that was passed on in the Treaty of Paris? In which case, are we following a colonial past or are we following our real histories? And again, to build a just and humane society, a government that shall embody our ideals and aspirations, the our there again, is a question that we need to is a term that we need to interrogate. Next slide. The Philippines is a democratic and republican state, given that there are many people that would rather do do deliberation in a particular way. When we say democratic, do we only mean a vote? Or do we say participative in such ways that cultures or all cultures become relevant? Sovereignty resides in the people, and all governmental authority emanates from them. I would hazard a guess that the concept of sovereignty here can include the kinds of sovereignty that existed before the colonizers came. And therefore, this provision actually recognizes that our collective sovereignty resting on different peoples is the foundation of our republic. Next slide. Again, Article 3, Section 1, again the word person for due process, person for equal protection. Article 13, Section 16, a more affirmative formulation of the role of people and their organizations to effective and reasonable participation at all levels of social, political, and economic decision-making shall not be abridged. Notice that this is unique to the Philippine Constitution, and that therefore I think this recognizes the multi-ethnic, polyvocal, multidimensional character of what we consider as Filipino people. Article 13, Section 16. But there is more. Our Constitution qualifies the concept of people in its own four corners. And there is the qualification of people in terms of quotation marks, indigeneity / ethnicity. And of course, Muslim Mindanao. I agree with Dr. Owen Lynch that all of us are indigenous. But our law essentializes what are indigenous cultural communities or indigenous peoples. But on the other hand, again, we say that the Constitution qualifies people by this fact. Of course, when you read the Constitution, there are other identities that are recognized, unlike the Constitution from where we gathered main inspiration. Women, youth, subjects of ecology. I think there is even veterans, artists, and so on and so forth. And again, I say that our Constitution therefore recognizes the possibility of different identities participating in a particular way. Next slide. For indigenous peoples and the autonomous region in Muslim Mindanao, we have to understand the context of how the provisions came about. There were progressive constitutional commissioners. For example, Commissioner Pons Binagen was an anthropologist that participated in the crafting of Article 10, Sections 15 to 22, as well as the provisions on indigenous peoples. Negotiations were ongoing with the Moro National Liberation Front. There was already the Tripoli Agreement of 1976. In 1984, the Moro Islamic Liberation Front splintered from the Moro National Liberation Front. There were actual lobbies of the Cordillera People's Organizations at the Constitutional Commission halls, and of course, the insurgent character of the North National Democratic Movement had a regional character. They were asking for genuine autonomy in the Cordilleras. Next slide. The provisions that you have in your Constitution on indigenous cultural communities, and I loosely use peoples in order to connect it with the concept of people, are Article 2, Article 12, Article 13, Article 14, Article 16. Very briefly, next slide. Article 2, Section 2 recognizes and promotes the right of indigenous cultural communities within the framework of national unity and development. Recognizes the right of indigenous peoples. Next slide. Article 12, Section 5. In our mind, creates a new kind of property ownership and this of property entitlement. And this is ancestral land and ancestral domain. I would say new as opposed to the concept of time immemorial possession. And more of that I can explain if, in the open forum if we have time. But then if you notice in Section 5, the first paragraph uses the word ancestral land. The second paragraph uses the word ancestral domain. There must be a difference between ancestral land and ancestral domain. And on the other hand, that ancestral domain must be different from Article 12, Section 2, lands separated from timber, separated from water, etc. Domain must refer to a holistic whole. But in any case, we do have Article 12, Section 5. There is one case that attempted to interpret Article 12, Section 5, except that it resulted in an even vote, 7-7. This is the case of Cruz versus Ncip, where there is no controlling doctrine to that case, except that the petition was not granted because the votes necessary to declare the IPRA, Indigenous Peoples' Rights Law, as unconstitutional were not there. Next slide. Article 13, Section 6. The use of the word ancestral land as an exemption to agrarian reform. You have cases like Bayot versus Court of Appeals and Alita versus Court of Appeals, where the Supreme Court held that in spite of the 5-hectare limit for farmer beneficiaries in the CARP, ancestral lands can be limitless. And thus you do have certificates of ancestral land titles measuring thousands of hectares in Bukidnon, among the Higaunon, or thousands of hectares in different parts of Mindanao. The point here is that the concept of ancestral land also given a unique character relating to the identity again of indigenous peoples. Next slide. Article 14, Section 17, again the recognition of indigenous cultural communities' culture, that it should be strengthened and developed and taken in the formulation of national plans and policies. Then of course, Article 16, Section 12, advisory, the indigenous cultural communities may have an advisory role in terms of advising the President on policies affecting indigenous cultural communities. If you notice, as compared to the next set of provisions, next slide, next slide, Article 10, Section 15. For indigenous peoples or for indigenous cultural communities, the focus seems to be on participation in national policy and on recognition of some levels of property rights. But on the other hand, for two geographical areas, that of the Cordilleras and what is referred to, I think mistakenly, as Muslim Mindanao, that it has geographical scope apart from that there is a sharing of common and distinctive historical and cultural heritage, economic and social structures, and other relevant characteristics. Notice that these provisions are the provisions that create an autonomous region. And an autonomous region essentially should be different from any other kind of local government unit. And as a matter of fact, because it is not the same as any other government unit, then therefore there is asymmetrical relation among all the other local government units. And that obviously in relation to the national government that has dominance over certain kinds of policies, that it too has asymmetric relations. Because there is no media, I will now make another controversial statement. This looks like a sub-state because it is less than a state. And of course, a barangay can be a sub-state. And therefore, this appears to be some kind of a sub-state. And hence, in terms of our negotiations, we have always said that autonomy and sub-state seems to be the same, except that, of course, there is some emotive force in linking one label over the other. The point here is that there is authority to create an autonomous region in Mindanao. Next slide. Clearly, Section 16, the President shall exercise general supervision over autonomous regions to ensure that the laws are faithfully executed. And classic in terms of our administrative law and political law is the distinction between supervision and control. Clearly, there is some leeway given to those that officiate within the autonomous regions in order to be able to control their affairs. Next slide. Again, the default provision. Powers, functions, and responsibilities not granted by this Constitution or by law to the autonomous region shall be vested in the national government. The provisions on autonomy are flexible in the sense that Congress has a power to define the kinds of powers that the autonomous region can have. And under current law, the Organic Acts, Congress has even limited its own powers to amend these organic acts by increasing the required majority to amend or modify it. And they say in the current incarnation of the autonomous government in Muslim Mindanao that there is a requirement of 2/3 vote of both the House and the Senate in order to amend those provisions in the Constitution. Again, clear that there is power given to the Congress to actually define the powers that are granted to the autonomous area. Next slide. Congress shall enact an organic act. And looking at this entire provision, there is at the end a qualifier, consistent with the provisions of this Constitution and national law. Organic act is a kind of product of the legislature, which is mentioned separately from the concept of all other national laws. And it says here that the Organic Act must be consistent with the provisions of the Constitution and national law. The Organic Act itself, of course, is a product of the House and the Senate. And therefore, consistent with national law means that there are certain instances where the Organic Act may be able to trump existing national law. And hence, therefore, again, an opening given to the creation, both in the Cordilleras and in Muslim Mindanao, of a kind of government where there can be a lot of powers that are granted to that unit. Next slide. Well, this is insofar as the plebiscite is required. A plebiscite is required. Next slide. Section 19 was the time frame given to the first Congress, and Section 20 is a very interesting provision. Notice that the Congress is given almost carte blanche authority as to what powers to give to the autonomous region. Again, we are looking at constitutional provisions, not the current statute. And it seems that in the Constitution, it creates a very liberal point. It liberally creates a mechanism where more powers can be granted to the autonomous region. Now, whenever there is a new government that is created, of course, there are instances where you have to deal with a lot of birthing pains. And therefore, it is important to realize that if there are certain kinds of legal structures which already makes permanent a kind of structure and it doesn't work, then that may be a recipe for failure. Under the current provisions in the Constitution, a transition to higher powers may be allowed because it allows flexibility on the part of Congress. And by the way, when we say a law, then therefore it has to be passed by the House and the Senate and in a plebiscite in the relevant area. When we say a constitutional amendment, on the other hand, then you involve the entire electorate, all 30 million voters from Batanes to Mindanao. The Constitution, we think, already provides for some flexibility to try to recognize a lot of powers, to experiment, and to gradually grant the kind of genuine autonomy needed in Mindanao and perhaps even in the Cordilleras. Section 21, I'm sorry, can we go back to section 18? Okay. The Organic Act shall define the basic structure of government from the region, consisting of the Executive Department and Legislative Assembly, both of which shall be elective and representative of the constituent political units. A liberal reading of this, considering the aspirations of those that would want to make a proposal as to how to reconstitute the autonomous region of Muslim Mindanao, or what they may call a Bangsamoro government, can also mean that the kind of structure that is put in place can be something akin to a parliamentary form of government, because it says that the executive and the legislative must be elected, but it does not say that they have to be directly elected by the people. This may be more relevant in the sense that in the area now of the ARMM, the numbers among ethno-linguistic groups are skewed towards certain kinds of ethnicities, and that perhaps it is also important to grant certain powers to the new minorities that may be created within that area now covered by the ARMM. Next slide. Next slide. Okay. Conclusions. First, our Constitution works best at its margins, on those issues that have not been foretold by those who actually wrote it. Why? Many of these issues may not have been discernible given the system of knowledge that may have existed at the time of the writing of the Constitution. But it is these issues that challenge our dominant legal forums to discern the foundation of our most necessary legal document. It is with these issues that we soul search, and in doing so perhaps equip ourselves to imagine a different future, truly democratic and truly just. Next slide. All we need to do is examine these powerful and invisible stories that hold us back, that dominate our lives, define our knowledge, and structure our experience. But again, another warning. As a final quote from bell hooks, no need to hear your voice when I can talk about you better than you can speak about yourself. No need to hear your voice. Only tell me about your pain. I want to know your story. And then I will tell it back to you in a new way. Tell it back to you in such a way that it has become mine, my own. Rewriting you, I write myself anew. I am author, authority. I am still colonizer, the speaking subject, and you are now at the center of my talk. This is by bell hooks. Wait a minute. Isn't that what we lawyers do? That we actually take the pain of others and speak for them. Next slide. But then, if this is true, then what should be our role as lawyers? Next slide. Should we even attempt to be really great lawyers? Thank you very much.